It is my distinct pleasure at this time to introduce the Attorney General of the state of Kansas and my friend Derek Schimdt.
Three things I thought I might share some information on today. One is the public safety role of the office. That's probably the thing most people think of first when they think of the AG's office, even though that's a little bit ironic given our history of local control in Kansas. Our public safety role, at least on the enforcement side, is almost entirely by request of local authorities. In fact, I don't have authority or jurisdiction to go in and say we're going to take that case and handle it in most circumstances. That's the responsibility of the local district attorney, county attorney, local law enforcement agencies, and so we work very closely in a partnership role with local authorities in our public safety and criminal role. I'm going to say a word about our consumer protection role because that's a little different. We're very active on that, and then I want to sort of wind up saying a few words about some of the higher profile, you might call it federalism or federal overreach sort of litigation that I know has been of great interest at this point in Kansas and American history and has been a priority for our office. So that's kind of the game plan in the next few minutes. On the public safety side, as I've already suggested, our actual enforcement role, us going out and prosecuting a criminal case, is almost entirely by request of local authorities. And what that means here in Wichita-Sedgwick County is we don't do a lot of enforcement work because you all have a very strong, very robust, well-staffed, well-trained, capable local district attorney's office. That's been true forever, regardless of who's led, at least as long as I can recall. What exactly is it we're asked to do in the criminal prosecution realm? Or to put it a different way, from a management or leadership standpoint, how do I make sure we're deploying the resources we have for criminal prosecution work in a way that really does add value to the system and doesn't just sort of haphazardly replicate other capacity around the state? So we looked at data, and here's what we found out. We found out we get asked to handle a lot of homicide prosecutions, a lot of them, but they are almost always in small and mid-sized counties. Our average homicide prosecution is in a county of 9,000 people. That's the median. Half bigger, half smaller. We found out that we get asked to handle an increasing number, a rapidly growing number, of child sex crime prosecutions, Jessica's Law prosecutions. And I think that stands to reason if you think about it. Back in 2006, the legislature gave us substantially enhanced penalties for violent sex crimes committed against young kids. For that reason, we now see a sort of contest of those cases with the sort of vigor that historically has been reserved for homicide prosecutions. And so for the same reasons we get asked to assist with a lot of homicide prosecutions in smaller and mid-sized jurisdictions, we're now asked to help with a lot of those prosecutions. I actually think we add a great deal of value to the public safety system, not so much in the individual cases we handle, although they're important, but in the broader, if you want to say, advocacy role, leadership role, coordinating role. And in that sense, our role has a strong public policy connection. I like to think we've played that role well. We've certainly tried to. We appreciate the work of the governor and the legislators of both parties in both houses over the last 3+ years that we've worked on that, and we've gotten a lot of good done. We enacted a new state RICO statute that was a proposal out of Sedgwick County. We were able to get the consensus done on that. Hopefully that'll be a tool to be deployed to bring some of the sort of worst of the worst organized criminal enterprise leaders off the streets in Kansas, whether it's gang leaders or drug organization leaders. We've enacted a new anti-human trafficking statute, which again really originated with advocacy out of this community in Sedgwick County. It really has been a leader in prosecuting a number of those cases. There were some in the paper, I think, just this morning. Certainly yesterday, I read about them online. And we have more tools now, not just to get the bad guys, but also to support the victims, which can be a very difficult task with that particular category of crime victims. We had a historic special session of the legislature last fall where the governor and the legislature agreed to come back when they weren't scheduled to be in session, and in 2 days and only 2 days they got the job done and repaired our hard 50 sentencing law after an adverse U.S. Supreme Court decision that we thought put that within very important sentencing statute at risk. The legislature, I think to their credit, when we presented them with facts and information about the capacity to do forensic laboratory work around the state in support of every law enforcement agency in this state, whether it's metropolitan or the smallest rural agency. We showed them what we had. We explained to them that we simply don't have the tools we need in order to do the work that folks expect. And they've responded very vigorously. I'm optimistic that within about the next month and a half, we'll see a groundbreaking on the new KBI forensic laboratory to replace the old, outdated headquarters laboratory in Topeka. And finally, on the public safety side, let me just mention, I know there may be some interest here, we have been in the business of administering the state's concealed carry licensing unit since it was established before my time. We have seen, as you all know, a huge influx in interest in concealed carry permits over the last 3 years. In fact, we have processed something like 2/3 of the entire number of outstanding permits on our watch in the last 3 years. It's been an enormous spike. Got a little bit ahead of us about a year ago. We resized. We're now, I think, back to where we need to be. We're now turning around permits in about 30 days after we get them from the county sheriff. And that's an acceptable number, well under the 90 that it was. So I hope we have that service being provided the way it ought to be provided at this point. Share a little bit of information about our consumer protection work. Unlike public safety, where we're sort of the cavalry, the backup, if you will, responding to local requests, the legislature back in the 1970s decided that we ought to share authority for consumer protection work with every county or district attorney in the state. And so we do. And what that means in most of the state, again, you have a good, robust capacity here, and D.A. Bennett's decided to make that a priority, so Mark's really built on that during his tenure in office. We work hand in glove with them. But in most counties in the state, there is zero dedicated local capacity for consumer protection work. And that makes sense if you think about it. The county attorneys are up to their eyeballs doing all kinds of things we don't have to worry about, whether it's traffic prosecutions, the misdemeanor prosecutions, the juvenile prosecutions, the day in, day out felony work. They have to prioritize resources. They focus on all of those things, and they are more than happy to leave the consumer work to us in most counties in the state. And so historically, and it's true on our watch, we have tried to construct capacity to handle that. We'll intake a consumer complaint right from you or anybody else. Unlike a criminal complaint, we're going to send you to a law enforcement agency. You can call our folks. We have agents we'll assign. We'll do the investigation. We'll do the litigation. We'll do the recovery. And assuming we get something back for you, we'll actually provide the check back to you at the end of the day for whatever you were ripped off. And that's not true just on our watch. That's historically been true. We've tried to build on that capacity because I think Kansans expect it. We've had a fairly robust capacity in our consumer division. We set a new record last year for the dollar amounts recovered. Now that's in part because we had a couple of large settlements. I mean, I'm not trying to overstate, but it's not solely because of that. We recovered about $49 million for Kansans in the public treasury last year in our consumer division alone. And you know, that's everything from door-to-door sales to no-call violations to the national mortgage settlement, which was one of the big ones that we were involved in last year. So we do a lot of work on the consumer side. Let me say a little bit about some of the federalism work of the office. This is a fairly new area for us. I haven't actually gone back and run the numbers, but I'm going to assert, and I think it probably is true, that we have sued the federal government more in the last 3 years than the Office of Kansas Attorney General has sued the feds maybe in its history before that. I think that's probably mostly a sign of the times. You know, some of the dynamics with our friends in Washington in relationship to the states. There is a real intellectual debate underway in this country, and it's not just in the ivory towers. I mean, it's at a lot of the cafes around the country about whether or not the federal government still respects any legally enforceable limits on its authority, or whether we have sort of morphed into more of a parliamentary system where if you got the votes, you can do it. My own view is the Constitution still means something, and that when we say that we have a federal government of limited and enumerated powers, we mean it, and that ought to be a judicially enforceable position. And so, you know, we have engaged on a wide variety of cases with that principle in mind. Certainly the highest profile probably was the multi-state challenge to Obamacare, the Federal Affordable Care Act. We didn't win everything we wanted on that. We won more than some thought we were going to. And the reason they're having a Medicaid expansion debate on policy grounds now in Topeka is that we removed the one-size-fits-all federal mandate as a consequence of that litigation, and now every state decides whether that makes sense for Kansas, and I think or for their own state, and I think that's the way it ought to be. We're now engaged in some second-generation litigation on Obamacare. We're involved in 2 lawsuits challenging the so-called employer mandate as distinct from the employee mandate, the individual mandate that we challenged in the first round. I think we've got a good shot at this. We'll see that the first of those cases is on its way up the appellate ladder back on the East Coast, and I would anticipate eventually one or more of those will reach the Supreme Court and they'll address it again, but we're following that closely. We're also engaged in quite a bit of litigation regarding the Environmental Protection Agency. Perhaps uniquely among federal agencies, the EPA seems to have a penchant for testing the boundaries of federal authority and the boundaries of delegated authority by Congress. A lot of that action is detrimental to the interests of Kansas, at least in our view. And so when you have a case where a federal action is harmful to Kansas, where we think it is unlawful or at least not clearly lawful, and we think there's a good legal case, those are the types of cases we engage in, because I think that's where most Kansans want us. I think it makes sense. It's an appropriate role for the office, and we've done quite a bit of that. So we were the first state to file suit against EPA challenging their so-called cross-state air pollution rule. Our name is not on the case caption. That's captioned with I believe, Texas first, I think. We were actually the first state to file, but a group of states joined in, and Texas, our dear friends down there, Greg Abbott, offered to foot the bill for the litigation, and I quickly said, yes, Greg, we'd be delighted to have your name first on the petition. So we worked that deal out. But we've argued that case at the Supreme Court, and we're waiting to see where that ultimately goes. We're also involved in the next generation litigation on greenhouse gas regulation. We now know that the Supreme Court's held that the Clean Air Act can cover greenhouse gas emissions, even though they weren't contemplated in 1970, whatever year the Clean Air Act was enacted. The Supreme Court held that they can be covered, but there still are processes that have to be followed in order for greenhouse gases to be regulated. We aren't convinced that EPA properly followed those, and so we're engaged in a challenge to that, a more typical challenge to a federal regulation. That's also a Supreme Court case. It's been argued. We're awaiting the results on that. Kansas also has involved itself, I've involved us in some Clean Water Act litigation. This is an interesting one. I was reading a newspaper editorial the other day from Baltimore, and I have no plans to ever live in Maryland, or certainly not to run for public office in Maryland, but if I do, I think I got a problem, because they know me and apparently don't like me very much. But Kansas led a group of states, Midwestern states, Republican and Democrat leadership, both in the governor's office and the AG's office, so it's not a partisan issue, in filing a brief objecting to how EPA has gone about regulating runoff, nutrient runoff in the Chesapeake Bay region. Now, why on earth are we, meddling, as they would put it, involving ourselves, as we would put it, in a runoff issue for a watershed that we're not close to? The answer is this, that the way EPA has gone about that is that it has essentially claimed the authority, and the states in that region didn't object, probably because they liked the outcome on the facts of that case. EPA claimed the authority not only to control sort of the aggregate levels of nutrients that can be in a watershed, but to bore down one step beyond that and tell states by order, here's what you have to do in this particular sub-watershed in order to achieve that maximum amount, compliance with the maximum amount downstream. The problem with that is, A, we don't think the Clean Water Act allows that level of federal micromanagement. In fact, we think it specifically disallows it, because the act was structured to be this sort of cooperative federalism agreement where the feds are involved in setting the requirements, but the states figure out how to get there. And that's a fundamental distinction. And two, when you're talking about runoff as opposed to point source, I don't know how you further manage or control that without controlling land use, which is a property rights issue, which historically has been in the purview of states. And so we think that's a really important Rubicon not to be crossed, because our concern is if that precedent stands in the Chesapeake, it will then be replicated by EPA in the Mississippi Basin. And we do have a big dog in the fight in terms of the management of runoff, whether it's from farm fields or suburban lawns or otherwise, in the Mississippi Basin. Bottom line, I think everybody's on board, I certainly am, with the notion that we shouldn't have a heavier load of nutrients in the water than the water can properly bear, but we are not on board with the notion that the ends justify the means, and if that's where we are, it justifies the feds saying, well, notwithstanding the law, we're going to tell you how you have to get to a better outcome. And so that's why we're engaged in that fight, and we'll see how it all goes. But the stakes are actually very high for a state like Kansas that has a relatively small federal delegation, so our power in Congress is somewhat limited just by our size. Not by our capacity, but by our size, and has a huge interest in land use, particularly in our more agrarian areas. So we're in and sort of swinging on that. Last one I want to mention, not because it's perhaps the biggest deal in the world, but because I think it's a really fun case. And you probably read some about it. This is the whole National Labor Relations Board and the Presidential Appointments Powers case. The issue there, it's really an interesting case. Happened to be the NLRB, but it could have been any federal agency. The President had a number of folks he wanted to appoint to the board. The U.S. Senate said we're not going to confirm them, either affirmatively rejected them or just didn't give their consent because there was a disagreement between the Senate and the President on the propriety of those individuals serving on the board. We think that's the way the Constitution set the system up to work. The President had a different point of view, and when the Senate briefly recessed, didn't adjourn, but recessed, the President stepped in and made the appointments anyway. We think in violation of, more than 2 centuries of American history, where it was the Senate that decided whether or not the Senate was in recess. It was not the President that decided whether or not the Senate was in recess, simply because he didn't like what the Senate had done or failed to do. We're involved as an amicus supporting the Senate in that. We're doing that because not only on the facts of that particular case, we think it's in Kansas' interest, but in the broader scheme of things, for a small state like Kansas with a light population, the dominance, or at least the strong role of the U.S. Senate in our federal system is a huge deal going forward. I mean, the great compromise that got us the Constitution more than 2 centuries ago, where small states and big states alike had equal representation in the Senate, while in the House you have this population representation. Anything that undercuts our equal representation in the U.S. Senate is not good long-term for a state like Kansas that's relatively lightly populated. So we certainly don't want to see this president, or any president, simply deciding that the Constitution's prerogatives given to the Senate don't count. And that's why we care about this case long term. So that's kind of a quick and dirty overview. Thanks for letting me share that information. I'm sure there might be some other subject matter you'd like to talk about. I'd be happy to do it, and we'll go from there. It's good to be back.